5 seconds to go. Start. Even if we were to accept the respondents' argument at its highest that the pandemic has resulted in an internal disturbance, we find that the economic slowdown created by the COVID-19 pandemic does not qualify as an internal disturbance threatening the security of the state. The pandemic has put a severe burden on existing, particularly public health infrastructure, and has led to a sharp decline in economic activities. The Union government has taken recourse to the provisions of the Disaster Management Act. However, it has not affected the security of India or of a part of its territory in a manner that disturbs the peace and integrity of the country. The economic hardships caused by COVID-19 certainly pose unprecedented challenges to governance. However, such challenges are to be resolved by the state governments within the domain of their functioning under the law in coordination with the central government, unless the threshold of an economic hardship is so extreme that it leads to disruption of public order and threatens the security of India or of a part of its territory. Recourse cannot be taken to such emergency powers, which are to be used sparingly under the law. Recourse can be taken to them only when the conditions requisite for a valid exercise of statutory power exist under Section 5, that is absent in the present case. The need for protecting labor welfare on one hand and combating a public health crisis occasioned by the pandemic on the other may require careful balances, but these balances must accord with the rule of law. A statutory provision which conditions the grant of an exemption on stipulated conditions must be scrupulously observed. It cannot be interpreted to provide a free rein for the state to eliminate provisions promoting dignity and equity in the workplace in the face of novel challenges to the state administration unless they bear an immediate nexus to ensuring the security of the state against the gravest of threats. Thus, it is not this court's stance that judicial review is stored in cold storage until a public health crisis tides over. This court retains its role as the constitutional watchdog to protect against state excesses. It continues to exercise its role in determining the proportionality of a state measure with adequate consideration of the nature and purpose of the extraordinary measures that are implemented to manage the pandemic. Democratic interests that secure the well being of the masses could be judicially aborted to preserve the unfettered freedom to conduct business of the few. Therefore, we find that the judgment dated 8th October 2020 of the Madhya Pradesh High Court was correct in holding that clause 2.3 of the 2020 MTT guidelines was a proportionate measure in ensuring the availability of sufficient domestic stock of PPE products. The measure was validly enacted in pursuance of legitimate state interest and did not disproportionately impact the fundamental rights of the appellant. Hence, clause 2.3 passes muster under Articles 14, 19, 1G and 21. For the reasons noted in this judgment, we see no need to interfere. Stop.